Okay, we're back on live stream again. Before you start, Mr. Cherniak, we asked that all council give us their schedule for March, April of 2021. Can you send that to the caseworker?
I'm completely open at this point. I have no unavailable dates.
Oh, okay. And then in addition, all of the written submissions for argument, if you could forward that, a copy of that to the caseworker, it would help us as well.
Yes, sir.
Okay, Mr. Cherniak.
Thank you. From first appearances, Mr. Chair, it may seem like there are two extremes in this hearing. On the one hand, you have NEC trying to show that the city is being too restrictive on developers. On the other hand, you have my client trying to show that the city is allowing the developers too much height and density. In the middle, you seem to have the city, the region, and the landowners who accept the supposed compromise position. But Mr. Chair, although it may be tempting to view the matter that way, I submit that it would be a gross mischaracterization. As we have heard time and again, the complaints from NEC are largely site-specific issues for Phase 2. Despite all the questioning and drama, NEC, the developer, takes no real issue with the major themes of the city's proposed secondary plan modifications. TSMJC came into this hearing with concerns about the ring road, density, and holding provisions, but that landowner was able to reach a settlement that deferred its major issues to Phase 2 and amended the plan even further toward what you might call the side of the developers. Doliola has been clear throughout that its land has been held back by the interim control bylaw. And I should mention, I appreciate Mr. Kagan's comments about what I've been able to do during this hearing. Thank you. Doliola's case sounds very sympathetic, but do not forget that when Doliola's lands were frozen in 2017, it was seeking to build 15 stories with 3 to 4 FSI. Now, after waiting for 3 years, the city is offering 5.0 FSI on its site, and Doliola is planning to build up to a 39-story tower. This landowner has not been hard done by over the past 3 years. Yonge MCD is also supporting the city plan, but that is after the city expanded the KDA further north into its lands and allowed 5.0 FSI throughout that section. The city's proposed modifications in 2020 are not a compromise between landowners and residents. They actually represent the city's best efforts to give the landowners as much height and density as can be justified. Those modifications are based on a unit size that is 150% of the actual average unit size, thus significantly underestimating the number of residents at 4.0 FSI. The city minimizes this error, but I will be arguing that it is a fatal error to the proposal for 4.0 FSI. That is why my client opposes this 2020 modifications. This hearing was not pro-development versus anti-development. This was a hearing about how high and how dense this KDA should be, how parks should be distributed in the KDA, and how the final plan fits into the larger Richmond Hill context. In my submissions, I'm going to discuss the following issues: the proper test under the Planning Act, the HDR Transportation report, the overall density, the holding provisions, the height regime, the plan for parks, and the larger Richmond Hill context. So first, the Planning Act. Although I'm sure the tribunal understands this, I always think it is important to restate the appropriate test at the outset of submissions. So I am going to share my screen. And what I'm showing here is City of Toronto and Gold List. This was a Court of Appeal decision where it explained at paragraph 13, and I've highlighted that, the most relevant portions in the Planning Act bearing on the right of appeal to the OMB and its basic powers on the appeal are sections 1724 and 1750 respectively, which read as follows. If the plan is exempt from approval, any person or public body may, not later than 20 days after the hearing that the giving of the written notice under subsection 23 is completed, appeal all or part of the decision of council to adopt all or part of the plan to the municipal board. So it is the plan in section 1724 that is being appealed, or in this case, the amendment to the plan. And what we're referring to is the 2017 secondary plan, OPA 8. On appeal, and then we go to 1750. On an appeal or a transfer, the municipal board may approve all or part of the plan as all or part of an official plan, make modifications to all or part of the plan and approve all or part of the plan as modified as an official plan, or refuse to approve all or part of the plan. I submit that means that this tribunal can approve all or part of the 2017 secondary plan. It can make modifications to the 2017 version of the secondary plan and approve the modified plan, or it can refuse to approve all or parts of the plan. The modifications being proposed by the city are not themselves the plan. They are the proposed modifications to the plan. That is an important distinction because it grounds the starting point for this tribunal's work. It is not the tribunal's job to review the proposed modifications and either accept or reject them. It is the tribunal's job to review the 2017 secondary plan, OPA 8, and it should only be modified where the plan itself is wanting. When I say that, I recognize that the evidence has not been focused on the 2017 version of the secondary plan. I have brought the witnesses to it on the issues that are most important to my client, but my client did not have the resources to hire its own planner. I'm fully aware of that. To the extent that evidence may be missing on this point, it was due to the city's decision to abandon the 2017 secondary plan. The city had every right to take that risk, but it should not benefit from its failure to lead evidence that this panel should have had before it to make a decision. As I admitted at the outset of this hearing, my client was in no position to put on a full defense of the 2017 secondary plan. Instead, it has proposed to accept large portions of the 2020 modifications, and it seeks changes only in specific areas that I will highlight later in my submissions. My submission on this point is that when the tribunal does propose to accept a change based on the 2020 modifications, it should be with regard to how that 2020 modification changes the 2017 secondary plan. And the decision should be that the modification is better than the 2017 version, not simply that the 2020 proposal can be justified, but that it is preferred over the 2017 version. I submit that the Planning Act does not give this tribunal the power to adopt an entirely new plan holus bolus. Without reference to the plan actually being appealed, it only has the power to modify the plan that was appealed and approve the plan as modified. And I submit that the reasons for those modifications should be clear. Now I'm going to turn to section 2.1 of the Planning Act. I also submit that because OPA 8 is the planning instrument at the heart of this hearing, section 2.1 of the Planning Act must be read with that in mind. This is it here. It's from a case Ajax that I'm going to get to in a moment. So 2.1 says that when the approval authority or the tribunal makes a decision under this act that relates to a planning matter, it shall have regard to A, any decision that is made under the act by a municipal council or by an approval authority and relates to the same planning matter. So in this hearing, we're talking about the 2017 secondary plan. And B, any information and material that the municipal council or approval authority considered in making the decision described in Clause A. I submit that this can only mean information that was before Richmond Hill Council when it adopted the 2017 secondary plan. Of the documents that we have looked at closely, that includes the 2017 staff report, the urban strategies report that's at tab 21 of Exhibit 1, the BA report, and map 1 to the staff report, which shows the proposals from the landowners at the time, and that's Exhibit 60. I'm now going to comment on the status of the 2020 proposed modifications for a moment. Vice Chair McCooch clearly decided that this tribunal has jurisdiction to consider those modifications. My client has accepted that decision and moved on. But the Vice Chair did not determine whether those modifications were a decision made under the Act. I refer to paragraph 65 of his decision. To the contrary, what Vice Chair McCooch found in paragraph 65 is that the proposed modifications were adopted pursuant to section 239 of the Municipal Act, and it constituted providing instructions in connection with pending litigation before this tribunal. Mr. Chair, I submit that this tribunal should have no more regard to the proposed modifications than it would have to a proposal by any party to amend a plan under appeal. In support of this proposal, I submit the case that's in front of you, Ajax and Pickering, which I submit is on all fours with this case. In Ajax, the town passed a bylaw, then later opposed it at the OMB. Ajax argued that the OMB should have regard to its decision to oppose the bylaw after adopting it. In 2018, the divisional courts, this is an appellate decision, rejected that argument. The OMB interpreted Section 2.1 of the Planning Act as requiring the OMB to have regard to the decision of the municipal council that enacted the bylaw under consideration. You can go on to 17. Ajax has argued before the OMB that Section 2.1 also directs the OMB to have regard to the decision of the Ajax Town Council to oppose the bylaw and appeal the passage of the bylaw to the OMB. The OMB rejected Ajax's interpretation of Section 2.1 of the Planning Act as being inconsistent with the plain reading of Section 2.1. Since Ajax had no jurisdiction under the Planning Act, since Ajax had no jurisdiction under the planning instrument under consideration, it is not the municipal council referenced in Section 2.1. Now, it just occurred to me that I think I said that Ajax adopted the bylaw. So that was incorrect. It was Pickering that adopted the bylaw. The key point here, though, is that Ajax had no jurisdiction over the planning instrument under consideration. Similarly, in this case, once the city of Richmond Hill adopted the 2017 OPA, it was the LPAT that had jurisdiction. It was no longer the city of Richmond Hill that had jurisdiction. And I don't believe the city disputes that. So once the jurisdiction was with the LPAT, Richmond Hill was no longer the approval authority, and its decision after 2017 is no longer something to which this tribunal must have regard. I'm going to go on for a moment just in case you don't agree with this argument. I do note that this tribunal is fully aware that the city has not provided any information or materials that were before council when the proposed modifications were adopted. You've ordered that the materials at the meeting the previous day are not relevant to such an analysis. Nothing stopped council from passing a motion to make all of its closed meeting materials public, just as they moved the instructions to they made the instructions to their lawyer from the closed meeting public. Council has a right to give instructions to its lawyer, and its lawyer has a right to advise this tribunal of those instructions. But such instructions cannot be construed as a decision under the Planning Act. By failing to disclose its considerations in adopting the 2020 modifications, and by failing to give the parties notice of the information that was before City Council during the meeting, I submit that the city has put this tribunal in a position where it cannot possibly have the sort of regard contemplated by Section 2.1 of the Planning Act. If it did, it would allow the municipality to cloak its planning decision in darkness without any negative consequences, and there would be no reason to avoid doing the same thing in the future. Indeed, any municipality could do it. I'm going to move on now to the HDR Transportation report. I don't think I need to share my screen anymore. Actually, sorry, I'm wrong, I do. Many times in this hearing, we heard that the HDR report analyzed scenarios up to 4.0 FSI. Mr. Wong from HDR was clear that he relied on the city to tell him the number of units in residential and commercial GFA that 4.0 FSI would represent. He could only comment on what would be possible based on the assumptions that he used. The numbers the city HDR the numbers that the city gave to HDR were based on the average residential unit of 110 square meters or 1,183 square feet. I'll come back to that a bit later. The city's director of policy planning, Patrick Lee, agreed that this was too large. When I asked him whether the average is closer to 650 square feet, he agreed without exception. Mr. Lee went on to say that this did not concern him because he thinks we cannot really predict how this will play out in 20 years. But Mr. Chair, if that is the case, then why do we have a transportation report at all? Surely the purpose is to try to predict what will happen in 20 years, and it should be based on proper assumptions. There was also some suggestion yesterday in closing submissions, yesterday, that perhaps this number included common areas like hallways and amenities, the 1,183 square feet. Mr. John Lee made a mistake under cross-examination and initially pointed to the removal of commercial areas as a removal of common areas. However, he noticed his error and showed that the common areas were clearly removed later in the calculation. Thanks to that line of questioning, we know two things. Firstly, York Region uses 110 square meters as representing a unit including common areas, a residential apartment unit, including common areas. 2, we know that Richmond Hill made a mistake and used that same size after removing common areas, effectively counting the common areas twice. I'm going to discuss what this mistake means for the KDA throughout my comments, but I want to mention at this time the credibility problem. If my client had not been asking questions about this issue, it never would have been drawn to the tribunal's attention. How did the planning department in Richmond Hill make such a major error? What other mistakes did city staff make? It's unfortunate that Mr. Terziewski did not return to tell us his opinion of this error, because in his evidence, he advised that he could not account for the estimate of the number of residents. Frankly, I submit that this tribunal should be concerned that the planning department that put together the 2020 modifications made a mistake such as this and expressed no real concern from a planning point of view. In any event, what we know as far as the HDR report is concerned is that HDR was asked to prepare a report that analyzed a scenario with 4.0 FSI. HDR was told by the city what percentage of the gross floor area was likely to be residential. And you're looking at those numbers here on the screen. HDR was told by the city how many residents would be living in the KDA based on 4.0 FSI. And Mr. Chair, all of this would have been perfectly reasonable if the city had given HDR the right numbers, but that is not what happened. Instead, this tribunal has been given a traffic analysis or transportation analysis based on an estimated number of residential units that is approximately 2/3 of the actual number that should be expected. This is if you assume that the average unit would be 800 square feet, multiply it by 150%, and you have 1,200 square feet, which is about the same as the city's assumed average unit. So HDR completed its report, and HDR seemed to determine that 4.0 FSI could be managed with some specific infrastructure improvements. But it did not actually do that. What HDR really determined was how a build out of about 2/3 of 4.0 FSI would work in this KDA. Mr. Chair, when we were just looking at the number of units, we were also looking at the changes in GFA from BA group to HDR, and that's what's on the screen here. Patrick Lee explained that Richmond Hill is hoping to see more office space in Richmond Hill, and that is supposed to account for the difference in office space assumed here. But he did not point to a policy that would ensure that sort of change. In his evidence, Carl Wong agreed under cross-examination that if he had been told to estimate more residential floor area, it would have resulted in more residents and more traffic during the AM peak that he studied. So this assumption from Richmond Hill was another factor in limiting the number of residents considered in the HDR report. This tribunal also heard evidence that HDR only reviewed the AM peak hour. This was contrary to the BA report, which considered the AM and PM peaks. Mr. Segoben advised that he was not aware of a similar study that did not include the PM peak. And unless I missed it in his reply, I do not believe Carl Wong offered an example that did not include the PM peak. Mr. Segoben also advised that there tend to be more commercial trips during the PM hours. I submit that this is very important, Mr. Chair, because HDR assumed a higher percentage of commercial and office space than BA group. So not only did it increase the commercial GFA assumption, but it removed, not only did HDR increase the commercial GFA assumption, but it removed the PM peak hours when that commercial GFA is most likely to result in transportation problems. It is just one more example of how the assumptions underlying the HDR report removed from its reliability and value. We heard a lot of evidence as well about HDR's consideration of the modal split and the possibility of whether transit could become 30% of that split. Mr. Wong's justification for this number was to point to other parts of the GTA. He compared the KDA to areas like Yonge and Steeles or Don Mills and Finch, and that comes from his, I believe, reply witness statement. Mr. Wong backtracked from this under cross-examination yesterday. He doesn't say that he backtracked, but that's the way that I construe it, and I submit that his witness statement speaks for itself. Mr. Wong also suggested that the KDA was likely to be even more successful than Yonge and Clark, where the modal split is already 23%. I submit that Mr. Segoben showed why these comparisons are inappropriate. In Exhibit 63, Mr. Seagoben showed the proximity between Yonge and Clark, Yonge and Steeles, and Finch Station. That was one of his maps. He also showed the fine grid road network that gradually becomes stronger as you go south toward the destination of transit users. This is completely different from the KDA area, where there is no east-west grid between Yonge and Bayview, there is no proximity to a subway, and the street network and transit ride get worse instead of better as transit users travel south into the village core. The final issue that I'd like to highlight about HDR's report is the capital projects. In its final report, HDR stated, and I'll turn to that right now. So in its final report, and it's the bottom paragraph here, HDR stated, based on the above results, it appears that 3.0 FSI would be the maximum supportable if additional road improvements beyond the 10-year capital program were not constructed, and if transit mode shares do not increase beyond 17%. When I put this to the transportation witnesses, they all agreed that this means the 10-year capital program is required just to support 3.0 FSI. Mr. Seagoben agreed that the capital projects could be built alongside the infrastructure. So that was something that Mr. Kahar was able to get from him in cross-examination. But not one single witness before this tribunal could answer whether the Elgin Mills grade separation over the railroad tracks was fully funded. They only knew that it was in the capital plan and that it is supposed to be completed by 2026. Yet they just assumed it is going to be built, despite no knowledge or evidence to support that assumption, and supported no holding provisions prior to the capital projects being completed. The final capital project was the Bathurst road widening. I just want to note that Mr. Wong was quite certain that this project is required to go beyond what he thought was 3.8 FSI. I will return to this later when I'm reviewing the holding provisions. Okay, I'm gonna remove the share for now so we can all see each other again. Mr. Chair, as I've already mentioned, it has become apparent through the course of this hearing that the city incorrectly estimated the average size of a residential apartment in the KDA. I discussed the effect that this had on the traffic report, but you heard evidence from Ms. Anderson yesterday that this does not really matter because all of the holding provisions are based on the number of residents and jobs, and I'll come to those holding provisions shortly. But what Ms. Anderson's comments do not explain is how this will affect the overall density when the KDA is fully built out, because the holding provisions do not go all the way up to the full build out. We heard evidence on a regular basis that the numbers in this secondary plan are planned out to 2041. Patrick Lee, the city planner who was responsible for this plan, said it would be at least 20 years. But that still leaves an open question. Which numbers are we talking about? The plan suggests a maximum of 11,300 residents and 3,000 jobs for a total of 14,300. Sorry, the 2020 modifications say that. But we now know that the residential component of that number is wrong. If you multiply 11,300 by 150%, the actual number of residents could be as high as 16,950. There is not a single report or policy that analyzes or speaks to such a high residential population in this KDA. Whatever the number of actual residents, I think it's a fair question. How did the city arrive at 4.0 FSI in the first place? Patrick Lee is the Director of Policy Planning for Richmond Hill, and he has been since 2009. He told us that when the 2010 official plan was prepared, it was the first new official plan for Richmond Hill in 30 years. It was the city's first foray into planned urbanization instead of just developing greenfield. All of the work that went into that plan is what led to the proposed density of 2.5 to 3.0 FSI in this KDA. When the secondary plan process began in 2016, the city did what one would expect. They hired urban strategies and various experts to put together options, consult the public, review the existing infrastructure, and eventually propose a final version of a secondary plan. I'm not going to turn to it, but in section 4.2.1 of its preferred options report, Urban Strategies explained that it was using 2.5 to 3.0 FSI because that was what the official plan determined as appropriate. And I don't think there's a surprise there. BA Group then did a study based on 3.0 FSI and determined that it was the maximum that could be supported in the KDA with a site to 2031. Patrick Lee the city planner did not even bother going back to BA Group for the 2020 modifications because he understood that they would not recommend anything higher than that, even with the revised assumptions. Based on all the work that was done, those experts in 2017 were able to recommend 3.0 FSI for 2031. Right up until April 2019, the city was also prepared to support that density in front of the LPAT. And we heard that the preferred option of the region's planner, Ryan Wong, even today, would be to see the 2017 secondary plan in force. I asked Mr. Lee how the city decided to pursue a potential FSI of 4.0 for the KDA. I appreciate that he candidly agreed that this began with council. Specifically, it began with the April 2019 motion to change the city's position only 2 months before the city was prepared to defend 3.0 FSI. Mr. Lee described how he could see why these sorts of changes were necessary when he thinks back to it. He did not want to call that hindsight, but I did not know what other word to use. The only justification Mr. Lee gave for 4.0 FSI other than council's motion was that it was the next logical number after 3.0. That does not seem like a particularly robust analysis to me, Mr. Chair. We know that once 4.0 was tested based on the wrong number of residents, the city put together a plan for 4.0 and an argument to support it. But we cannot forget that they were only able to do it because they underestimated the likely number of residents. I'm not suggesting malice or that it was intentional, but that was the way it turned out. We do not know what the recommendation would have been if the correct number of residents had been used from the outset. I'm actually going to take a step back from that because I submit that if you focus your sights solely on the area to be developed, you could probably put together a planning explanation for a high density enclave just about anywhere with enough water and sewers. Surely, though, the analysis needs to go beyond that. Why do you have to put this high density KDA here in this particular location? And why does the density have to be the highest possible density that can be supported by the transportation infrastructure? I submit that it is not good enough to answer that it is the next logical step beyond the official plan. Neither is it good enough to say that it is what the politicians want. Instead, the density proposed for this KDA should be consistent with the planning for Richmond Hill within the larger policy context. To go beyond the density of the official plan, surely there needs to be a better explanation than what we've heard, that this is the most people who can be fit into the area based on local transportation. My client proposes to limit maximum FSI within the KDA to the number that HDR has been able to fit into the number that HDR has actually been able to fit into the transportation infrastructure. The YRA provided a schedule with the FSI on the individual properties, which is its position on where this should all go. And that's in its document book. I believe it's tab B1. The changes the changes essentially lower each block to something similar to what was proposed in the 2017 plan. I do have to apologize. My client did not have the expertise to calculate what this would lead to in FSI, but it did estimate in its proposed change to policy 12.2.3 of the secondary plan that it would be 3.0 FSI. And the numbers do seem close to 3.0 FSI if you compare them to the 2017 plan. If they're higher than that, then it leaves some room to maneuver in phase 2. What I'm going to do now is return to John Lee's calculation from his witness statement. So this I will share again. So we went through this a bit yesterday, but I think it's really important to go through it again and make sure that we're all on the same page. I'm happy to take questions on it if necessary for clarification. I'm happy to take any questions for clarification, in fact. So the concept that Mr. Lee tries to follow in paragraph 17 is that the city has taken gross floor area and assumed a number of units based on that gross floor area. That number of units translated into a certain number of residents and jobs. Based on that assumption, HDR did its study, and the May 2020 modifications were proposed. Mr. Lee is trying to walk the process backward in a manner that does not invalidate HDR's study, but still takes into account townhouses and other variables not affected by the error in apartment unit size. His goal is to determine what HDR was actually studying using the same number of residents and jobs. By removing all the GFA that was not included, which would otherwise have been available to add more residents. So essentially it was double counted as the common elements, and determining what FSI HDR actually considered. And before I proceed, I am going to note this is a mathematical calculation. I submit that it is not an opinion or something that requires expertise. So the KDA ground floor area, and I'm looking at paragraph 17, is 826,783 square meters. If you assume an average unit size of 796.5 feet, or that translates to 74 square meters. So the city has overestimated the residential unit size by 36 square meters, 110 minus 74. The city has also calculated 5,080 apartment units, and that comes from Exhibit 38. I'm not going to turn to it, but that's what it says. So if you take that number, 5,080 units times 36 square meters, you have a total of 182,880 square meters. So that is the space that was not accounted for in the calculation, or that was double counted as common elements. Now, before I move on, I want to note that if you divide that number, 182,000, here it is, 880 square meters, by the average apartment size of 74 square meters, you will find that there can actually be an additional 2,471 units. That's not shown in this calculation, but those are the numbers, and it's in my written materials if you want to look at them again. So there are 2,471 units missing, and that leads to an additional 4,695 residents beyond what the city has estimated and beyond what HDR has considered. That number comes from the city's assumption, which is in Exhibit 38, that there will be 1.9 residents per unit. Mr. Kussner suggested that Mr. Lee's evidence on this point is insufficient because two small apartments could have more people than one two-bedroom apartment. I submit that this is a red herring. It is the city that has provided the average of 1.9 residents per unit. When the city provides this average, they are accounting for exactly the sorts of oddities noted by Mr. Kussner. If the city's position is that its own estimate of the number of residents in an apartment unit is wrong, in addition to being wrong about the size of the units, then we really have no idea how many people might live in this KDA. I submit that Mr. Lee cannot be faulted for relying on the city's average of 1.9 residents per unit. But I've digressed from paragraph 17 here. So,
Jeanette, could I interrupt just one sec? Yesterday, you did something with your earphones to eliminate the static. Could you try that again if you recall what it was? Because there's quite a bit of static in your feed.
Okay, we'll see if I can do it here. Is that any better? Does that help at all? Okay, I've switched the wrong thing.
Sorry, I'm not. Yes, that helps. Thank you.
So this works now?
Yes, thank you.
Okay, I'll just note if my children come home, you'll hear them because I'm no longer using the headphones as a microphone. So I think I'm back to the number 182,880 meters squared in paragraph 14. So this represents, as I said, the amount of GFA that is not included in the city's calculation. The total GFA, and this comes from the city, is 826,783 square meters. If you subtract that 182,880, what you end up with is 643,903 square meters. So that is the actual developable area that was calculated when HDR was given its numbers. Sorry, that was the GFA that was calculated when HDR was given its numbers. You then divide that by the developable area. So this number, 643,903, divided by the developable area from the city, 215, and what you get is an FSI of 2.99. It is only if you add those other 4,900 some odd residents I mentioned that you would actually be looking at 4.0 FSI. So what we learn here is that due to the city's error on average unit sizes, they actually only asked HDR to review 3.5 FSI all over again. And Mr. Chair, I submit that explains why the total number of residents and jobs only went up from 12,000 in 2017 to 14,300 in 2020. So that was an increase of 19%, even though the FSI seemingly went up by 33% and the size of the KDA increased by 25%. It seems to me, unfortunately, none of the experts spoke to this. It seems to me that this is really the increase in the KDA sizes has led to more residents and jobs and not the FSI. This shows that based on the number of units assumed to determine the population, and that's the population that HDI relied on to make its recommendations, the actual FSI that HDR considered was 2.99 and not 4. On that basis, the overall FSI should be set at 3.0 because that's what HDR was able to support. The board has an excellent example of what a 3.0 FSI map might look like, and that's the 2017 secondary plan, which this board does have jurisdiction to approve in whole or in part. I'm going to turn now to the matter of the densest neighborhoods. And I want to make one. John Lee went to a lot of trouble to prepare a chart of the highest density neighborhoods in Canada based on the 2016 census. And when he took us to it, I thought he did a good job of explaining what the census data showed us. I also thought that his point was clear. This is what neighborhoods with a density similar to the proposal for the KDA in 2041 look like today. Mr. Lee agreed under cross-examination that they are generally likely to grow larger by 2041, but that wasn't his point. Mr. Lee's point was that even 20 years from now, the Yonge and Bernard KDA infrastructure will likely look nothing like today's Yonge and Bloor, or the Yonge Street corridor from Finch to Shepherd. Those areas today, which are Canada's highest, the densest neighborhoods, are far beyond what this KDA will look like in 20 years from an infrastructure point of view. I submit that that point was not only well made, but it should be well taken. There is no need to plan the Yonge and Bernard KDA to have enough residents in 2041 that it could compete with 2016's Yonge and Bloor for density. I submit that the evidence about the wonderful infrastructure at Yonge and Bernard, such as the value of the bus station in the middle of a bedroom community, and the massive growth that we should expect when the Yonge subway comes south, are overstated. The evidence was clear that we should not expect a subway in Richmond Hill within 10 years. The evidence was clear that we do not know whether the railroad grade separation is fully funded. The evidence was clear that there are major constraints to those who want to travel east-west out of the KDA. Although Mr. Wong argued that traffic could go north to 19th Avenue to travel east, I submit that the route he recommended through a residential neighborhood is not realistic from a planning point of view. I also submit that we need to go back, that the need to go back south to get to Elgin Mills highway entrance after driving a mile north to 19th Avenue makes it an unlikely and inconvenient alternative. Even Mr. Wong eventually admitted, I think under cross-examination from Mr. Iskander, that those further south would likely take Elgin Mills instead. He could have also noted that the KDA is further south. Mr. Wong's evidence on this point, I submit, should be rejected. And it also calls into question his analysis that suggests that the yellow arrow on Elgin Mills can be resolved by expanding the study area a mile in both directions. And I think they will turn that one up. And this is a, oh, sorry, that's not it. Page 2714. This is a different version, but it shows, I think it's a different version, but it shows the same map. There's the yellow arrow there, the green along there. So what this is showing is that there is a problem if you look at Yonge and Elgin Mills running east on its own, but if you expand the area all the way to 19th and Major Mac and give people an opportunity to go somewhere other than Elgin Mills, then it becomes green. So that was Mr. Wong's evidence. Mr. Segovin's evidence was that that does not cut it. And I submit that to accept that analysis, it is also necessary to accept the suggestion that residents are going to take a circuitous route north to avoid Yonge Street through the residential neighborhood to get to 19th. And then when they get up to 19th, they're going to go a mile back south to get to the Yonge and Elgin Mills highway entrance. or north to Stouffville Road, which is even further out of the way. And in fact, when I first cross-examined Mr. Wong back in July, I suggested to him that people in the KDA might prefer a drive to the Stouffville GO train instead of a bus to the Newkirk bus terminal. Mr. Wong told me it made no sense to drive backward to travel forward. I submit that his attempt to make precisely the same argument that he rejected only 2 months ago is another firm knock to its credibility. I submit that Mr. Wong's various attempts to compare the Yonge and Bernard KDA to areas in Markham and Toronto are unconvincing. In fact, as I mentioned, he seemed to resile from them under cross-examination yesterday. He tried to suggest as well that the subway coming north will automatically bring its modal splits north. But he had to admit that he does not know how long it took for Yonge and Finch to reach its current modal split. He also had to admit that the proximity from Yonge and Bernard to Highway 7 is similar to that between Highway 7 and Finch. So when the subway eventually goes to Highway 7, Yonge and Bernard will be 2 kilometers further north than Yonge and Clark is from Finch, another reason why they're not comparable. There are major transportation constraints around this KDA, and it is not an appropriate location to be planning one of Canada's densest communities, based on the evidence that I submit should be relied on. I'm going to turn now to the holding provisions. We heard multiple witnesses say that even if the KDA densities seem high, the holding provisions ensure that they will not go higher than can be sustained by the local transportation infrastructure. Mr. Kussner and Mr. Kahar made those same submissions this morning. So I'd like to review whether that's the case. So I'm going to go to this in, I think I'm going right back to the page I was on before. 2754. So the starting point for the holding provisions is 10,400 residents and jobs. This is the number that HDR uses to represent 3.0 FSI. So we know it's wrong, but I do agree with the city that for the purposes of the holding provisions, the number of residents and jobs is more important than FSI. So HDR's finding here is that based on the above results, it appears that 3.0 FSI would be the maximum supportable. The language is I think I may have said this already. I apologize if I did. The language is a bit awkward, but Mr. Wong agreed under cross-examination that this means the 10-year capital program is required for 10,400 residents and jobs. And the Bathurst Road widening, or a 30% modal split, is necessary to go beyond 10,400 residents and jobs. That's what this paragraph means. And you may remember that although the 10-year capital program is required for 10,400 residents and jobs, the holding provisions do not require that the work be completed before the hold is lifted. Mr. Sigobin agreed that as a general rule, these works can be completed at the same time as development. And that's fine. But as I mentioned, not one single witness could answer my question of whether the railroad grade separation is fully funded. Even the region's witnesses, 2 months after I first asked the question, were unable to confirm this. I submit that there was an onus on the city to prove that this infrastructure improvement, which all transportation witnesses agreed to be necessary, actually has some certainty of being built. One might respond that surely if there was proof it is not fully funded, I would have put it to the witnesses. And Mr. Chair, I can only say it's very difficult to prove a negative. It's particularly difficult to prove that a government does not have the funding to do what it is promised to do. They do not tend to advertise that sort of thing. I submit that there is not sufficient evidence for this tribunal to determine that the grade separation will be built by or near the year 2076 as proposed. So despite this, the YRA is not proposing to require all capital projects for future development. I'll go to the YRA's proposed holding provisions. Here. So the YRA is not proposing to stop all development until the capital projects are complete. Instead, what they've done is they've lowered the number from 10,400 to 7,500 when the capital projects do not yet need to be complete. What that does is essentially it's prudent because we don't know whether the grade separation will be completed. It will eventually have to be completed to get up to the 10,400 residents and jobs that HDR says are appropriate once all those capital improvements are complete. And this is all based on Mr. Segovin's professional opinion. Mr. Kahar did challenge Mr. Segovin on this because he did not just require completion or construction of the regional projects over 7,500. As you can see, he's also looking at either the modal split or the Bathurst road widening to get over 7,500. Mr. Segovin insisted that this remained a properly prudent approach, and he did not back down on that. The YRA also proposes to add a unit number to the holding provisions. In her evidence, Ms. Anderson said that this is not necessary. However, she did agree in cross-examination that it has been done. Through Mr. Minette, I introduced an example of that in the Seaton zoning bylaw excerpt. That was Exhibit 61. In that case, the number of units was the basis for a hold depending on a transportation study. In her reply evidence, Ms. Anderson gave the opinion that even with the unit size errors, the actual population limits in the holding provisions would be sufficient without unit limits. I submit that this does seem to resolve the unit size problem as far as the first three holding scenarios are concerned, A to C. But it does not solve the problem where the city assumed a higher percentage of commercial and office development than it did in 2017. Because HDR's report assumes that of those first 7,500 or 10,400, there are less residential than there are actually likely to be without that assumption of a whole bunch of extra office space being built. So the way to correct that is to put in a unit count, which limits the maximum number of residential units within that 7,500 or even within the 10,400 if it's at a higher level. This ensures that when the buildings are actually built, the landowners are not able to use that wished for office space as residential space instead. Or at least if they do, it limits how many buildings they can build. You would also, I think, tend to encourage the office space. It's for that reason. So you can see the proposed limits that my client and Mr. Segovin have proposed here. Unfortunately, again, my client is limited by its means, but just by a rough calculation, if you look at 6,000 residential units times 2, that's 6,000 people plus 1,500 jobs. In the next level, you would have 8,000 people plus another 2,000 jobs. The final holding row would impose the residential limit that was considered in the HDR report. All residential units planned for would be allowed, 5,570. So that includes the number we saw for apartment units earlier, plus townhouses and institutional. And that would lead to a maximum of 11,300 residents, because this says less than 5,570, not more, up to or more than 5,570. So once you reach that number, there can be no more residential development approved. Please note, there is not a limit on the number of jobs that can go into the area based on this proposal. It is only the residential numbers that are limited, because that seems to be the real concerning factor in this KDA. And I'll just note as well that this is related to issue 4. Should the total number of residential units in the KDA be limited? And if so, what is the appropriate maximum? So without the unit limit that my client is proposing, once the KDA reaches 12,650 jobs, so residents and jobs, so that's the city's version, there can be no further development until there's a 30% modal split on Yonge and a 20% modal split on Bathurst and Bayview, and Bathurst is being widened. There are further amendments related to that last requirement. I'll come to those later. Right now I'm looking at the May 2020 proposal. Once those requirements are met, though, under the city's proposal, there are no further restrictions other than the maximum FSI for the KDA. The concept mostly comes, again, from the HDR report. That's from here. And it's this paragraph. Based on the above results, scenario 2 and 3, which incorporates higher transit mode split along Bathurst Street widening, respectively, is required to permit development within the KDA beyond 3.8 FSI. What they, for them, 3.8 FSI was 13,400 residents and jobs. When both the higher transit mode split and the Bathurst Street widening improvements are attained, then development to 4.0 FSI will be permitted. I submit that this is clear. Once those three requirements are met, development only to 4.0 at the highest, which HDR represents as 14,150 residents and jobs, can proceed. HDR did not recommend allowing more residents and jobs than that under any circumstances. But the holding provisions, as written, put no similar maximum on the density. As I noted earlier, this number, 14,150 residents and jobs, actually refers to 3.0 FSI, not 4.0 FSI. My final point on the holding provisions relates to the amendments from Exhibit 74, sorry. The city witnesses candidly advised that they added the holding provisions themselves at the request of the YRA. Oh, I seem to have the wrong exhibit number. Oh, I'm sorry, I opened up the tab instead of the exhibit. Okay, maybe I won't turn to it right now. Hopefully you'll recall as I discuss it. So the city witnesses, something's happened. Okay. The city witnesses candidly advised that they added the holding provisions at the request of the YRA. They also advised that they switched the first column from FSI to residents and jobs at the suggestion of the YRA. Coming into this hearing, it seemed that the YRA and the city were actually making common cause on the concept of holding provisions, although we did not agree on the exact numbers. But even after council endorsed the proposal, the city brought it into this hearing, and the city had support from all but one landowner, and the objecting landowner was TSMJC. Even NEC supported those proposals. With all of that support for the holding provisions as proposed by the city decided to take one step back to reach a deal with TSMJC. And what it's done is it's potentially removed Project G in its entirety, and it's changed the definition of existing and approved development so that there is no building permit. So if there is no building permit issued, it is like the project does not exist. Now, the other landowners signed on, and I can't blame them because it reduces the restrictions on their land. But initially they were fine with what the city proposed, and the YRA was prepared to accept. So I'm going to start with the last column in Project G. That's the Bathurst Street widening. We already looked at the HDR report, and I submit that it is very clear in opposing development beyond 13,400 residents and jobs unless that Bathurst Street road widening is completed. And in fact, HDR's opinion was so clear that when Mr. Wong came back as a reply witness, the city lawyers did not even ask him for his opinion on the change regarding item G. Ms. Sterling gave evidence in opposition to including the Bathurst widening, so that seems to be where this change comes from. Her opinion was that if it is removed from the region's long-term planning, that it should no longer be a holding provision. I do take her point that from a certain point of view, it might not be fair to a developer to acquire a project that is potentially not going to be built. But I submit that Ms. Sterling misses a key point in this analysis. Without the Bathurst widening, HDR would not have found support for what it thought was 4.0 FSI at all. Presumably, if Bathurst Street widening weren't even a consideration, the city would now be proposing a maximum density of 3.8 FSI, which is what HDR thought it could allow for without the Bathurst widening. Ms. Sterling's proposed solution is to remove the condition altogether if the Bathurst widening is removed from the regional plans, even though the transportation report says it cannot be accommodated. And that's the position that all the landowners in the city have now, in the region, have now taken. I submit that has it backward. If the project necessary to allow for development beyond 13,400 residents and jobs is removed from the plans, then development should be limited to 13,400 residents and jobs pending further study and review, or until a new project is proposed that can accommodate the expanded population. Although it came through Mr. Minette, when I was cross-examining him, I think it was clear that I submit that the seat and zoning bylaw applies here.
The OMB has approved holding provisions on development in that case. They require a traffic study in compliance with the results of that study. There is no requirement that a holding provision be within the control of the landowner. Also, I would argue that a planning opinion on the proper use of holding provisions should have come from a professional planner and not a transportation planner. I'm going to move to the other change regarding existing and approved development. So the attempt to change the definition of existing and approved development, I must admit, is the most disappointing change that I've seen in the modifications in this hearing. Let me see if I can actually share it properly now. Okay. So I'm going to scroll down to where the change actually is. Here we go. If nothing else, with the holding provisions as proposed, there was a limit to ensure that development almost certain to go ahead would have to stop at 10,400 residents and jobs unless there was a significantly higher transit use or Bathurst road widening. In some ways, that 10,400 residents and jobs number acted as a limit on development for at least the next 10 years. The change to this definition of existing and approved development removes, or at least lessens, the value of that particular hold. And I think you have to look at how it works in practice. The first question in this number one column is, are there under 10,400 residents and jobs? If the answer is yes, then development can proceed without a hold. With the original definition of existing and approved development, this would have required a count of all site plan approvals, draft plan approvals, or development that has already had its servicing allocated. In essence, it would have required a count of all the projects that one could expect to see built in the near term. With the new proposal, the limit is now only on the number of building permits issued. You could easily have a situation where there are enough building permits issued to allow for 9,500 residents and jobs. There might be 2 major tower projects from different landowners that are already site plan approved, bringing the prospective number of residents and jobs well above 10,400. Meanwhile, when a third tower project applies to have its H removed, it can ignore those other 2 towers that have been site plan approved. And it could also be approved, putting the number of residents and jobs far beyond 10,400. And it's important to note as well that, let's say that third tower is approved and then suddenly the building permits get above 10,400. The holding provision cannot be brought back. It's already gone. So that third tower will still be able to proceed, and the number of residents and jobs will be beyond 10,400. Mr. Chair, I urge you to consider not only the backtracking on this issue in favor of the landowners, but I also ask you to consider how the city's planning witness was able to change her opinion on this topic. And I do recognize that people can change their opinions, but I think it's important to remember here that on one day, I think it was June 23rd, we had a witness statement supporting the holding provisions as proposed by City Council. 2 weeks later, we had oral testimony recommending a change that had only been sent to the YRA a day or 2 before that evidence was given. When Ms. Anderson gave that evidence, she seemed to suggest that it was innocuous. And as she said yesterday, she thought it added certainty. To be fair, I suppose the change does add certainty that all projects being counted have building permits, but it does not add any certainty that the number of residents and jobs will remain below 10,400 until the other required conditions are met. This change allows the landowners to leapfrog over the holding provisions, contrary to the recommendations of HDR, and it should be rejected for that reason. I'm going to move on now to the height limits. And there's been a lot of evidence about the policy-based height regime. The city's experts all opine that this allows for flexibility and that it is becoming more common within the urban design profession. Oddly, examples of secondary plans that use such a regime without maximum heights were missing in evidence. Patrick Lee mentioned one site-specific case in which Mr. Streisfield was involved. He said there are others, but he did not seem to be able to give any specifics. The city did not introduce any of those OMB or LPAT decisions either. I must admit I was somewhat disheartened by Mr. Lee's evidence on this point. As late as February 2020, in the city's draft proposals, Richmond Hill planning staff were recommending a building height limit of 30 stories along Yonge Street and 18 to 25 stories in interior character areas. Despite Mr. Lee's comments regarding building height, I find it hard to believe that all those OMB and LPAT decisions that apparently forced him to give up on building heights were issued between February and May of 2020. If that were the case, I expect that the city would have provided them as part of its closing submissions. When I listened to Mr. Lee's testimony on this point, what I heard was that the city of Richmond Hill has given up on trying to maintain the height character of the buildings that are built here. For decades, Richmond Hill has imposed lighting restrictions citywide to protect the night sky. Since 2010, when the town started growing up, it has tried to keep buildings lower and wider instead of allowing them to rise high and, again, block out the sky. This does not necessarily decrease density, it just changes the built form of that density. Yes, it may be true that Mr. Lee has not had a lot of success in enforcing his preferred height restrictions. It may be because the official plan limits most heights to 15 stories outside Richmond Hill Center, and that's just too low to be realistic in today's city. But it does not necessarily follow that the answer is to get rid of height restrictions altogether. When I cross-examined Mr. Theodore, he agreed with me that tall buildings out of place can stick out like a sore thumb. He also agreed that from the point of view of an existing detached home neighborhood, it might be preferable for shorter buildings to be built before taller buildings. To me, these seem like principled reasons to put some sort of height limit on development, particularly when it's infilling an essentially flat area like the KDA where nothing is higher than 3 stories. I have to say, I could be wrong, there's no confirmation, but it seemed to me from Mr. Lee's evidence that in his heart of hearts, he actually agrees with that. He's not trying anymore. But as Mr. Lee said, he's had enough of being overruled by the LPAT. So instead of attempting to refine the argument, perhaps raising the proposed maximum height, he and the planning department are giving up on maximum height altogether, at least in this KDA. Now, the evidence from the other witnesses confirms that height limits are actually quite common throughout Ontario. In the Richmond Hill official plan, I submit that they are even required. In support of that submission, I refer to section 3.4.1.39 of the official plan. I'll have to open it still. Okay. There we go. Page 622. So this is it here, Mr. Chair. Development within the centers and corridors, so that includes the KDAs, shall be designed to, then you see approved by the OMB, provide built form that maintains a well-proportioned human-scaled street wall, minimum and maximum building heights, including maximum podium or base building heights are set out in Chapter 4. So I submit that that reference to the minimum and maximum building heights in Chapter 4 is an instruction that this official plan requires maximum building heights. And that's been approved by the OMB. I'm going to turn now to one of the cases that I'm referring to. It's a Court of Appeal case called Niagara River Coalition in Niagara-on-the-Lake. And I'm looking at paragraph 43. Further, the proper interpretation of an official plan is not a factual matter to be decided based on opinion evidence from planners, but rather a question of law. And then at 45. It is clear that official plans are not legislation, and where interpretation is necessary, it is a question of law that must be determined on the basis of the documents that comprise such plans. In this instance, the application judge relied on opinion evidence that was inadmissible to determine the scope and meaning of the language used in the plan. So I'm not suggesting Ms. Anderson's or any other planner's evidence was inadmissible. I think it's fair to take it into account, but this panel should not give up its discretion and rely on that evidence entirely. This is an interpretive matter to determine what the official plan actually means in this section that I pointed to. And it is ultimately up to this panel to decide whether the Richmond Hill official plan requires the imposition of maximum height limits in the centers and corridors. We do know from Mr. Lee that there's another LPAT decision that did not require it, but that is not binding on this particular panel. So firstly, I submit that the plain wording of this section leads to the conclusion that it requires maximum heights in the centers and corridors. I also submit that the existence of height limits for every other part of Richmond Hill in the official plan is further evidence that it is the correct manner of interpreting this policy. I'm not going to turn to them all, but policy 3.1.3.7b says that Richmond Hill Center will have the highest level of intensification in the town, including the greatest height and density. And then policy 4.2.1.23 says that the limit in that area is 40 stories. And I recognize that bonusing was still allowed when that was written, but nevertheless, there's a maximum height. Then policy 4.4.1.8 allows up to 20 stories in the Yonge and 16th area, Yonge and 16th KDA. But for TSMJC's appeal, the OP also contemplated a maximum height of 15 stories at Yonge and Bernardi. And there are more maximum heights. Obviously, I'm not going to turn to all of them. After reviewing these policies, Mr. Chair, I submit that this panel should find that maximum heights are required in Richmond Hill and that the OP does not allow this KDA to go, and, so a second finding, the OP does not allow this KDA to go above the Richmond Hill Center limit of 40 stories. In the evidence, we heard of other 40-story limits as well. Mr. Theodore agreed with me that the effective height limit for the Vaughan Metropolitan Station is 42 stories. Other planning witnesses mentioned buildings as high as 40 stories in Mississauga, the Pickering Town Center, and the Markham Civic Center. I apologize if I've missed one or two, but all of those height limits represent the tallest buildings allowed in the primary intensification area within those municipalities. So that's comparable to Richmond Hill Center and not Yonge and Bernardi. None of those were, none of those examples, I don't believe they were examples of a policy-based height regime. If they were, there was no evidence to that effect that I recall. Surely, at the very least, this KDA should be limited to no higher than all those other areas that are intended to hold even more people. There would be no prejudice to any party if this tribunal were to impose a 40-story height limit. None of the proposals before this tribunal show a building higher than 39 stories. And the evidence is that in 2017, there were no concepts to which you must have regard that went above 37 stories. That's a reference to map 1 to the staff report that was marked as Exhibit 60. Now, on the matter of height, there was a lot of evidence surrounding the city's demonstration plan. I pointed to the few places where there could potentially be 60-story buildings. And Mr. Theodore had to admit that if a builder wanted to throw caution to the wind and just build one tower as tall as the policies would technically allow, that 60-story tower could be built. Despite that, though, he maintained firmly in the opinion that the underlying densities would tend to keep buildings lower than 40 stories without any policy changes. So here's the problem that I have, Mr. Chair. Mr. Theodore's evidence on this point was without regard to Richmond Hill's mistake regarding average unit size. Now, I don't know whether that affects the demonstration plan. Unfortunately, the calculations that supported the demonstration plan were not provided. As a result, I submit that it is at least questionable to rely on the demonstration plan's use of the height limit and density in combination, because the density aspect may have been affected by the unit count problem. We were talking earlier about 182,880 square meters of residential floor space that was unaccounted for. If that was also unaccounted for in the demonstration plan, we don't have any evidence on how many extra stories that might allow for. The example we can turn to, though, was the plan that was provided by Doliola. And in that plan, I won't turn to it, but Lincoln Lowe confirmed that a compliant plan could have a total, so I think if you took the 4 towers and added them together, there could have been 127 stories. In contrast, the demonstration plan showed 112 stories on the same height. Now, Mr. Lowe did note that there were other changes such as podium height, so I don't propose to argue that all that extra height on the quadrant was due to an error by Richmond Hill. I'm even prepared to concede that perhaps different people prepared the 2 documents and one error did not affect the other. However, in light of Richmond Hill's major error regarding unit size, I submit that it is this tribunal should at least regard the demonstration plan with a critical eye and be aware that there might have been mistakes. And if it's going to impose a height limit of some sort, other than what my client proposes, I would submit it should be done to ensure that there are no unintended consequences, particularly if you can set a height limit that avoids prejudice to any parties in this hearing. And the city's evidence seemed to be that they were expecting nothing much higher than 40 stories based on the numbers. So I submit that, again, if you don't accept my client's recommendation, 40 stories, I think should be the maximum height limit that is imposed here. Now I will come to what my client proposes. So as you know, the 2017 secondary plan showed a maximum height limit of 15 stories. My recollection is that those planners who provided an opinion on the subject agreed that this height regime would allow for 3.0 FSI, and that's because the 2017 secondary plan was planned for 3.0 FSI. Theoretically, based on Mr. John Lee's calculation of the actual FSI considered in the 2020 modifications, these height limits could be reimposed with the exact same number of residents and jobs in this plan because it's the equivalent of 3.0 FSI. But Mr. Lee did say in his evidence that the YRA is trying to be reasonable. Instead, what my client has actually proposed is, so this is in, again, in its document book, Exhibit 38. So what it is actually proposing is a height limit of 25 stories, which is 66% higher than the original plan of 15 stories. It would also allow 15 to 20 stories in the interior character areas. I have to say, Mr. Chair, if you had told me that this would be my client's proposal 1 year ago, I never would have believed it. In his questioning of Mr. Lee, Mr. Iskander made a point of highlighting the YRA president's evolution toward accepting and even surpassing the 2017 secondary plan. When the February 2020 draft plan came out, I do not think there were any smiles among the YRA's board. What the plan proposed was a height limit of 30 stories, with 10 to 25 stories in the interior character area. Patrick Lee agreed with me that this was an example of a height regime that would accommodate an FSI of 4.0. So that 2020 draft was tab 82 of Exhibit 1. Now, I do not think it can be questioned that my client's proposed heights here could accommodate 3.0 FSI because they're significantly higher than the 2017 secondary plan. However, I don't have an urban design witness or planner who can confirm whether my client's proposed height regime could accommodate 4.0. When I asked it once or twice, the experts declined to guess, and I don't blame them. It seems to me that these numbers are close enough to the 2020 draft that they should allow for 4.0 FSI, but if the panel disagrees, then it would be appropriate to adopt the actual heights and map proposed in the 2020 draft secondary plan, because we know that that would accommodate 4.0 FSI. And of course, that's only necessary if the tribunal determines that 4.0 FSI is appropriate. So I've turned to that draft report now to show where it is. So this is it here. I should also note that my client's amendments include proposals to bring back the 2017 secondary plan language in policy. Well, it's in the document book. They bring back some of the height language as well to ensure that it applies to maximum heights because the 2020 modifications do not do that. I'm going to turn now to parks. So urban squares. When Patrick Lee gave evidence, he agreed that linear parks and urban squares come from the official plan. They are meant to serve as resting, meeting, and gathering places within the centers and corridors. In answer to Ms. Foran, he noted that there is also a reference to plazas as a type of urban square. And supposedly the change is a distinction without a difference. Mr. Lee did not explain why the proposed modifications to the secondary plan do not refer to those urban plazas as a form of urban square, though. In response to Mr. Kussner, Mr. Lee pointed out that the Richmond Hill Parks Plan is not a statutory document, but we've heard time and time again in this hearing that the city prefers to rely on citywide policies before making specific decisions regarding matters such as stratification. Why is it that when we come to a citywide parks plan, suddenly the secondary plan is a standalone document? The KDA, this KDA is meant to be Richmond Hill's third most dense intensification area. Mr. Minette noted that if the secondary plan is adopted, it will actually be the second most dense intensification area. Based on the evidence regarding the status of Yonge and Highway 7, there seems to be a good chance that it will be the most densely populated part of Richmond Hill in 20 years. With all of those people living in the KDA, Patrick Lee agreed with me that urban squares as defined by the official plan and deployed in the parks plan are exactly the sort of parkland that belongs in the KDA, so that they can be used not only by local residents, but by shoppers, employees, and others who visit the KDA. This is why the evidence about the ability to walk from the KDA to surrounding parks and the neighborhoods with attached homes is not sufficient. Urban squares were created in the official plan for a reason. They are more than local parks for local residents, and they belong in the Yonge and Bernard KDA as proposed in 2017. As I mentioned a moment ago, there was a suggestion that urban plazas mentioned in the proposed modifications are equivalent to and a replacement to urban squares. Firstly, if that's true, why the change in name? But secondly, for that to be true, the urban plazas would have to be mandatory. And in the 2020 modifications, they are not, whereas in the 2017 plan, urban squares are mandatory. That's from policy 12.3.2. Urban plazas would only be encouraged in 2020. From the landowners, we saw multiple concept plans that include no urban plazas at all, and even those that claim to be fully compliant with the policies. In her direct evidence, I think I recall Ms. Anderson agreed that urban plazas could be replaced by cash in lieu of parkland. In this hearing, the YRA's proposed modification has been to bring back the urban square language of the 2017 secondary plan. It has also brought back the open space schedule from 2017 to show where those urban squares would go. I'm going to move now to the larger Richmond Hill context. Throughout this hearing, I've questioned the overall direction of the 2020 modifications. Why is the city proposing to plan out to 2041 on the basis of an official plan with a view to 2031? The response from the planners has largely been that this does not concern them. We all know that the planning regime has changed in Ontario. We all know that the target is now 2041 or even 2051. And we all know that the Richmond Hill official plan from 2010 is being reviewed. I submit, though, that to the contrary, the growth plan is clear to the contrary. I'll turn to that now. That's policy or section 2.2.2.2, which is right here. This is the growth plan from the document book. Until the next municipal comprehensive review is completed and in effect, the annual minimum intensification target contained in the applicable upper or single tier official plan that is approved and in effect as of July 1, 2017 will continue to apply. So we know that the municipal comprehensive review is not approved and in effect. Mr. Eskander regularly asked which version of the various planning documents we should be looking at today, and I submit this is part of his answer. The growth plan also provides in section 5.2.4. Just want to make sure I'm looking at the right one. I'm looking at number 3 here. The population and employment forecasts and plan horizon contained in the applicable upper or single tier official plan that is approved and in effect as of July 1, 2017 will apply to all planning matters in that municipality, including lower tier planning matters where applicable, until the upper or single tier municipality has applied the forecasts in Schedule 3 in accordance with the policy 5.2.42, and those forecasts are approved and in effect in the upper or single tier official plan. So, Mr. Chair, perhaps I forgot, but I don't believe that any of the professional planners took you to this section. And if I'm right about that, it's surprising to me because it seems to me it's obviously an important consideration, when answering my questions about looking out to 2041 in the secondary plan. It seems to answer that question. As the province recognizes in the growth plan, even if there's some agreement that the 2010 plan is out of date and it's shortly going to be revised, it is not appropriate to move on before there is something to replace the 2010 plan. We all know that the common route for this plan, this secondary plan, would have been to base it on 2031 and adopt it or a modified version of it last summer. We know that so well that the preferred option of the regional planner would have been to have it in force as written in 2017. We also know that the city's director of policy planning never thought to change it until after a political decision by council. Even Mr. Minette, appearing for a landowner, did not think we should expect the secondary plan to remain as it is for much longer than 10 years. Despite all of this, Ms. Anderson and the landowners' planners, not to mention City Council, would have this tribunal bind the hands of the City of Richmond Hill for the next 20 years. The council elected in 2018 might have the ability to change the KDA, but not the council of 2022 or 2026 or maybe even 2030. Planning too far into the future with high densities is like appointing a young Supreme Court justice who can sit on the bench for decades. We all heard evidence about the MTSAs. Mr. Lee calculated it's in Exhibit 67 that Richmond Hill would have an extra 77,440 residents and jobs if you were to actually meet all those MTSA targets. If all 16 were developed to their full 500-meter radius, you'd be looking at something like 250,000 residents and jobs. Nobody expects that to happen, but it's worth being aware of. Nevertheless, the 2020 proposal is to set Yonge and Bernard at 3 times what is required by its MTSA. And make no mistake, this was based on the city's FLAWS unit sizes, showing that even at 3.0 FSI, the KDA is well beyond the province's minimum targets. If the 4.0 FSI is imposed, it would be even more beyond what those targets are. I do fully recognize that there is no requirement to spread development equally among all MTSAs. However, I also recognize that the decision this council first made to walk away from the 2017 plan came only 4 months after they were sworn in. About a year later, instead of proposing back of the napkin motions, they ultimately endorsed the recommendations of staff. Agree with them or not, this council does seem capable of changing. As they go through a proper OP review process, who knows what staff will recommend for 2041? Who knows what council is going to learn about the planning process? Who knows what sort of citywide plan might be approved? I submit that this tribunal should decline to plan this specific KDA out to 2041, firstly because of the growth plan requirements, but also out of principle, because to do otherwise, it would have to look solely at the specific KDA in a vacuum from the 2041 planning for every other part of Richmond Hill. It would also have to discount the context provided by the 2010 OP, which is the parent plan of this proposed secondary plan. The city and landowners are proposing to have this panel approve an official plan amendment without the context of an official plan with an eye to the same horizon of 2041, and it would be blind to other parts of Richmond Hill sailing toward that same horizon. I submit that it is inappropriate, premature, and not good planning. Now, unlike the other lawyers, I did not ask the planning witnesses whether the 2020 modifications conform to provincial policy. You may or you may not recall, but I asked Ms. Anderson whether she was aware of any changes to the provincial documents between 2017 and today that would require an increase in this KDA from what was proposed then to what is proposed now. Her answer was no. There is no evidence that the 2017 plan is not in conformity with the various provincial policies. There was evidence, however, from Patrick Lee that as late as April 2019, he thought there was conformity. And Carl Wong, the region's planner, was also of that opinion as late as when he gave evidence. For all the innuendo regarding the changes in the planning regime, no planner was able to point to a specific change from 2017 that required the 2020 modification. While we all recognize that the province has changed some of the goalposts, I submit that the original 2017 plan's focus on 2031 insulated it from the changes imposed for 2041, just as the growth plan requires. And there should be no surprise in this. The 2020 modifications only purport to increase the number of residents by 13% and the number of residents and jobs together by 19%. Based on the city's error in residential count, the 2020 modifications were analyzed as if they were barely an increase from the 2017 proposal. There is no principled reason why those numbers would be any more compliant than the 2017 numbers. So I'm on to my conclusion now. One final time, I'm going to remind this panel that the numbers are wrong. In actual fact, the city of Richmond Hill underestimated the size of an average apartment residence by at least 48%. As a result, it planned for 2,471 too few residential units, which, based on the city's estimate of 1.9 residents per average unit, results in 4,965 more residents than what any expert has analyzed. I know how this case looked when I began saying I did not have a planning witness. John Lee may be a smart and committed man, but you can imagine how many times I had to warn him that he was up against experts and he should expect that their opinions would be believed. And frankly, as his lawyer, I had to wonder how I was going to show that the 2020 modifications should not be adopted without a single planning witness to back me up. When Ms. Anderson gave evidence, I tried to challenge the unit size, but she was unable to give a firm opinion. Patrick Lee, though, this past week came to give evidence. He openly admitted that the unit size was wrong. He even agreed with me that something closer to 650 square feet would be appropriate. And remember that in my calculations earlier, I was assuming 800 square feet, so even larger than that. Suddenly, after years of effort, there was an expert witness who gave evidence that John Lee actually had a point. Under cross-examination, Mr. Kahar tried to show that Mr. John Lee was mistaken. He showed Mr. Lee the 110 square meter number came from the region, and that the region had included the common elements for each apartment in that 110 square meters. I think many people in this hearing were inclined to believe that Mr. Lee had made a mistake during that cross-examination. He seemed to think that commercial GFA was the same as the common areas. I suspect that there was even a sense of relief among some to be able to believe that the city did not make a major mistake and underestimate the number of residents by a factor of 50%. But John Lee remembered his error. He pointed out that in addition to the commercial GFA, the common elements for the common area GFA was also removed 3 lines lower. The net effect of this evidence was to show exactly what Richmond Hill did wrong. It took the residential component of mixed-use buildings, it removed the non-residential space, it removed common areas, and then it used the region's average unit size, which included common areas within it. The end result was that common areas were counted twice, and the residential population was vastly underestimated. The result is that all the discussion of 4.0 FSI was based on a miscalculation. When HDR reviewed the traffic, it missed almost 5,000 residents. We do not know what HDR's results would have been if they had used the right residential population for 4.0 FSI. When city staff prepared modifications to the secondary plan, they relied on the HDR report. We do not know what city staff would have proposed if they had used the right residential population for 4.0 FSI. When council endorsed those 2020 modifications, they could not possibly have known that they were recommending 5,000 more residents in this KDA than the staff report and modified plan suggested. Again, we do not know what they might have done if they knew. In fact, there is not one expert who has analyzed what 4.0 FSI would actually look like at the Yonge and Bernard KDA. Not Urban Strategies, BA Group, TMIG, Golder, or Savanta, they were all intentionally looking at 3.0. None of the planners who gave evidence in this hearing advised what they would do in a 4.0 situation with the proper calculation. None of the transportation experts in this hearing did either. Every single expert who has looked at this file missed the one hidden error that the city of Richmond Hill underestimated the number of residents by a factor of 50%. It took the non-expert John Lee fighting against all odds to reveal this major error. I submit that due to this major error by City of Richmond Hill staff, the proposal to plan this KDA for 4.0 FSI needs to be rejected because there is no evidence to support it. The only evidence before this board supports something closer to 3.0 FSI. Now, if you accept my submissions on this point, then I submit that the rest of the 2020 modifications have to follow. Surely, without a proper analysis of 4.0 FSI, we cannot determine how high the building should be because there is no evidence on how high they need to be to accommodate the actual number of residents and jobs at 4.0. The holding provisions do provide some protection, but they have no maximum limit to ensure that this area is not planned beyond what it can handle. All we know is that it can handle something close to 3.0 FSI. The YRA proposes a maximum residential unit count as a correction if this tribunal is prepared to proceed with 4.0 overall. But I submit that the only true protection is to lower the entire KDA to 3.0 FSI. Without a proper analysis of 4.0, I submit we also cannot know the appropriate parkland requirements. And we cannot know whether the proposed parkland in 2020 makes sense in light of the revised numbers. Particularly in light of the fact that the main linear park east of Yonge is unlikely to be built in the next 10 years through the TSMJC lands. Without a proper analysis of 4.0 FSI, I submit that this tribunal cannot find that the proposed modifications conform with any of the provincial, regional, or municipal planning documents, because there is simply insufficient evidence of what 4.0 FSI would actually look like. And there was no evidence from any planner of the effect of the actual 4.0 FSI. Finally, without a proper analysis of 4.0 FSI, I submit that this tribunal cannot find that the proposed modifications constitute good planning. I will not repeat the specific changes that my client recommends, but I submit that short of reverting back to the 2017 secondary plan, those changes are the best protection against this major planning error by city staff that is before this tribunal. Finally, I have to note, as I've noted many times, that my client has limited resources as a residents association. This was supposed to be a 7-day hearing in July. Instead, it's gone to 15 days, largely because one party, NEC, has persisted in taking up as much time as it possibly can at every opportunity. In doing so, it has argued the same matters time and again without any respect for the rulings of this tribunal. I cannot suggest that all the time over 7 days is due to NEC, but much of it is. On that basis, I'm advising that my client is reserving its right to seek costs against NEC. It will depend partly on the result, but it does seem that costs may be warranted even if NEC has some success. Those are my submissions, Mr. Chair.
Thank you. Okay. Mr. Costner.
Thank you, Mr. Chair. By way of reply, firstly, to the submissions from Mr. Streisfeld on behalf of NEC. Firstly, just as a general observation, it's my respectful submission that the submissions you heard today from Mr. Streisfeld lays bare his client's true intent to delay and derail this hearing process as much as possible. Respectfully, it's a scorched earth approach, and implicit and explicit threats to the city, to the tribunal, and to the other KDA landowners that there's going to be delay, there's going to be litigation, make no mistake about it. It was also in part a gripe session about previous rulings that have been made by this tribunal over the course of this hearing, rulings that were made in many instances back in July, which have not been subject to any requests for review or court proceedings, and which are therefore final and binding on this tribunal and on all of the parties. My friend Mr. Streisfeld took issue with the fact that in the draft order, the city is proposing that the secondary plan and zoning bylaw would not come into effect as it applies to the lands on the east side. And he suggests that this amounts to some kind of deficiency in what the city is seeking. To be clear, the city is requesting this tribunal to approve the secondary plan and zoning bylaw in their entirety, save and except for certain portions that have been deferred to the phase 2 hearing, like the Greenway, for example, but not bring the secondary plan or zoning bylaw into effect as it applies to the lands on the east side. So it continues to be a comprehensive policy regime in terms of what the city is asking this tribunal to approve. But as an accommodation to TSMJC, as part of the settlement that was reached, it was agreed that we would not be asking the tribunal to bring the secondary plan or zoning bylaw into force, the secondary plan into force as it applies to the lands on the east side of Yonge Street. And in fairness to Mr. Streisfield's client, we assumed what sauce for the goose is sauce for the gander. If we're not going to be asking for it to be brought in force as it applies to the lands in the southeast quadrant, it seemed as a matter of basic fairness to take a similar position as an accommodation to Mr. Streisfield, not to have it brought into force in the northeast quadrant. I find it rather shocking that we're now being held to task for what amounted to an accommodation to his client. As a matter of fairness and to ensure that there was a level playing field leading up to the phase 2 hearing. Mr. Streisfield took issue with the opinions that were provided by Ms. Anderson with respect to his proposed modifications or additional modifications to some of the Part 1 official plan policies. And this is the proposal to include the reference to housing options in the first 2 policies. In my submission, Ms. Anderson, Mr. Streisfield said, I just don't get it. Well, in my submission, I think Ms. Anderson was very clear on that point. These are policies that apply on a citywide basis. And before we go willy-nilly modifying policies of this nature that apply on a citywide basis, there needs to be a more comprehensive review and analysis of whether those policies are appropriate on a citywide basis. If those policies were solely limited to this secondary plan, that would be a different story. But because those policies by their definition had a much broader scope, it was her view that it would not be appropriate within the context of this secondary plan hearing to bring about modifications that could apply on and have implications on a much broader citywide basis. My friend, Mr. Streisfield, took issue with the fact that after this hearing started, only then was a policy brought forward dealing with the issue of stratification. And all I can say, Mr. Chair, again, this tribunal encourages settlements among the parties before it, as long as those settlements are grounded in appropriate planning policy considerations. In this instance, the city and TSMJC and certain other parties were able to put their heads together. Certainly it was a little later in the process than anyone would have liked, but we were able to put our heads together and come up with a stratification policy that satisfied the city's objectives, accommodated the ongoing stratification study, and was likewise satisfactory to TSMJC. And on that basis, it enabled TSMJC to defer all of their issues respecting the road network in the southeast quadrant to phase 2, precisely what we submit my friend ought to have done in the northeast quadrant. My friend made the submission that sites within this KDA, quote, cannot develop based on a traditional road system, unquote. Well, I don't think, in response to that submission, I don't think we need to look any further than Yonge MCD and Doliola. Here are 2 developers within this KDA, both of whom seem pretty satisfied to develop their sites based on a quote unquote traditional road system. My friend, I think implicit in my friend's submission was the underlying proposition that a municipality has some sort of obligation to justify the use of public roads, and there should in effect be a default assumption that private roads are preferable. My response to that is, when did this paradigm shift in planning occur? I'm not aware of any fundamental shift in planning under the Planning Act or any other municipal legislation that somehow imposes a reverse onus on municipalities to justify public roads as the foundational starting point for development, for new development within that municipality. That would be a paradigm shift that simply is not reflected in any legislation or in any planning policy that I'm aware of. And you certainly didn't hear any evidence to substantiate that proposition. My friend suggests that the concerns about the studies that are contemplated by the secondary plan. The proposition was that this all could have been resolved if the studies had been done at the outset. Well, you'll recall that when I was cross-examining Mr. Minette, I asked him, are you suggesting that the city has somehow delayed or dragged its heels in terms of the process of bringing these proposed modifications forward subsequent to the adjournment which was granted by the tribunal last June? His answer was no. He was not alleging that to be the case at all. So in my submission, the suggestion that the city should have been more diligent, that it should have acted more quickly and more hastily in completing all of the necessary studies is not only inconsistent with the evidence you heard from Ms. Anderson on that point, but also contrary to Mr. Minette's own acknowledgement and concession that the city was in fact proceeding diligently to bring forward what it could bring forward subsequent to the adjournment of this proceeding last summer. With respect to the assertion that there was no evidence to justify the proposed 15% non-residential component that's incorporated into the proposed policies, firstly, that's simply not the case. I refer you to the witness statements of Ms. Anderson and Mr. Theodore, both of which deal at some length with the proposed 15% non-res policy. Ms. Anderson's evidence, I believe, also referred to the staff report. The reference is Joint Document Book, tab 8, page 2460. It's page 34 of the staff report itself, which discusses the rationale for that 15% requirement. And I would similarly put the proposition that although Mr. Minette suggested a 10% figure might be more appropriate, there was absolutely zero analysis or justification done to justify why a 10% non-res component is more warranted than a 15% component. My friend suggests that the city was not alive to the need to move from a car-centric development paradigm to transit-supportive development. In my respectful submission, that's just completely contrary to all of the evidence that you heard from the transportation planners and the land use planners. And just by way of example, I would refer you to Mr. Dowell's reply witness statement. You don't need to go there, but table 2. That's just one specific example that shows that the city was clearly alive to that concern and is proposing to implement policies in the secondary plan that address that issue and implement a strategy to deal with the need to shift to more transit supportive development. But it's got to be one that focuses first and foremost on specific development applications so that the strategy can be tailored to the opportunities and constraints of a specific development application, the specific unit count, the breakdown, and so on. My friend suggests that he would be prejudiced by the 2-year moratorium on private applications to amend newly approved secondary plans. This is in reference to point 4B in his submissions. Firstly, as the tribunal is aware, it is always open to council to waive that 2-year moratorium on request. Secondly, if Mr. Streisfield's client had in fact filed a development application like other landowners did, such as Mr. Kagan's client, such as Ms. Ford's client, such as Mr. Annabelle's client for at least a portion of their site, they would be in the same situation and would not be faced with that 2-year moratorium. So with great respect, to the extent that that's a concern, NEC has only itself to blame for not having filed that application. And that's a specific concrete example of what it means to file a development application and why filing a development application actually does entail different rights than simply saying, I can just wait for the process to unfold. I should have my as of right zoning and I'm in no different situation from other landowners who have taken the time and effort to actually file a development application and submit all of the supporting reports and studies needed to justify a complete application. My friend takes issue with the policy or the proposed policy requiring applicants to demonstrate how they propose to meet the 35% affordable housing target. In reply, firstly, to the extent that that's a mandatory policy, it's binding not only on the municipality as the public authority, it's also binding on applicants. So when they are submitting a development application, they also need to comply with regional and local official plan policy. And to some extent, there is an onus on them to facilitate demonstrating how they propose to satisfy that policy. And the reality, Mr. Chair, is by virtue of this policy, in effect, the municipality is not proposing to dictate to development applicants how they ought to meet that policy. Rather, it's leaving it up to the developer. It's providing flexibility on a case-by-case basis to decide how they propose to meet that target, either from a marketing standpoint or housing tenure standpoint or unit size or unit count or what have you. The point is it's intended to provide greater flexibility to developers to assist and facilitate meeting that affordable housing target rather than dictating it to them from a top-down standpoint. My friend referred to Exhibit 35, the proposed modifications that were the subject of the settlement with TSMJC, and seemed to take issue with the fact that Mr. Terziewski was not subject to questioning on those mods. Firstly, I think it was clear from his own submissions that that document was still a work in progress at the time Mr. Terziewski gave his evidence. And you'll recall that he was a little concerned about giving evidence on it because the document hadn't yet been finalized. And Mr. Annabelle and I can both assure you that that document continued to be very much a work in progress, almost right up until the moment that it was filed as an exhibit. That's why you didn't hear any evidence from Mr. Terziewski on that point. The point Mr. Lee made when examined on that issue was it was his understanding that Mr. Terziewski was perhaps the principal author of those proposed modifications from the city's standpoint. But it was also clear from TSMJC's evidence that they and their consultants also had a significant role to play in the drafting of those policies. It wasn't Mr. Terziewski's attempt to foist something on other parties. It was a matter of consensus that was reached among willing parties and participants. My friend suggests that the policy proposed in terms of stratification amounts to a quote unquote watering down of traditional public roads. Well, firstly, if that's the case, why is he complaining about that? Doesn't that operate to his own client's advantage? Secondly, the watering down that he complains of was clearly acceptable to TSMJC, and it was sufficient to enable them to defer the balance of their issues regarding the road network to phase 2. Why was it not also good enough for TSMJC? I think the answer to that is self-evident in my submission. My friend also submitted again, and we've heard this before, that a pre-hearing conference disposition could never bind a merits panel. In reply, I just have 3 large question marks beside that submission. This tribunal on a regular basis makes rulings through case management conferences, pre-hearing motions that clearly bind the conduct of the hearing to be conducted and are therefore binding on the tribunal that conducts that hearing. I don't think I could put it any more simply than that. Lastly, my friend suggests that there's a housing crisis in Richmond Hill. Nothing is getting built in Richmond Hill. Then out of the other side of his mouth, he says, but you know what? Let's just delay the approval of the secondary plan for another 6 months. What's the big deal about that? Let's go back to the drawing board, start the hearing all over again once all these studies are complete, and just do the whole thing all over again in 6 months' time. So which is it? Is there a housing crisis that needs an immediate resolution? Or do we have the luxury of going back to the drawing board and starting all over again? I think the answer to that question is self-evident as well. With respect to Mr. Iskander, I don't have any submissions in reply. With respect to Mr. Cherniak's submissions, I'm just going to make a few introductory comments and then turn it over to Mr. Kahar to deal with the balance of it. Firstly, my friend raised an issue with respect to the tribunal's jurisdiction to entertain the modifications that are proposed by the city and other parties pursuant to your authority under Section 1750 of the Planning Act. And as I heard those submissions, my principal concern was that it struck me as an ex post attempt to perhaps relitigate issues that had already been heard and decided by this tribunal on pre-hearing motions. You'll recall, Mr. Chair, that when this hearing...
Mr. Chair, I said no such thing.
Okay. If I could continue. You'll recall that when this hearing was adjourned in 2019, it was for the stated purpose of enabling the city to go through a comprehensive process of bringing forward proposed modifications, taking them through a stakeholder consultation process, and ultimately bringing them forward for consideration by this tribunal. And that's precisely how the process unfolded. And the intent of that process was that when the city brought forward its proposed modifications, as recommended by staff, those proposed modifications would inform the issues that the parties brought forward for this hearing, and would in turn inform the evidence that was presented to this tribunal at this hearing. That's precisely how the process unfolded. And when you look at the issues list, that's why all of the issues are framed in reference to the city's proposed modifications, not the original adopted 2017 secondary plan. So while there's certainly no dispute as a foundational or jurisdictional matter that this tribunal derives its jurisdiction from the original adopted secondary plan, that's clear and it's undisputed. By the same token, it's also clear and undisputed that there was never any intention on the part of the city to justify the original adopted 2017 secondary plan. Council CIL made clear its intent that it was no longer supporting that plan. And it was also clear through the rulings made in the pre-hearing process leading up to this hearing that the city would be bringing forward and seeking to justify the proposed modifications that are now before you. So I think it's important to keep that context and history in mind when the suggestion is made that the city is somehow under an onus to justify firstly the 2017 adopted secondary plan, which it no longer supports, and then on top of that, justify the proposed modifications that it's now bringing forward. In my submission, that proposition is simply irreconcilable with the process that has unfolded and the previous rulings that have been made by this tribunal in the pre-hearing process in terms of how that process is going to unfold. With respect to section 2.1 with respect to section 2.1 of the Planning Act. Sorry, I'm hearing an echo here. To be clear.
Well, you may be hearing an echo, but I'm having a real problem. But hang on. I'm having a real problem with the audio. It's coming in and out, and I have not, I don't think, got half your.
Oh, it might be your connection. Mine's fine.
Oh, okay.
Connection to the internet.
I wouldn't, and I'm not sure how I correct this, but maybe, and it's just when you started the reference to the response to Mr. Cherniak and the jurisdictional issues. So maybe, hopefully from here on in we'll be okay, but that section, if you could write it out and submit it, I'd be happy. Okay, all right. Okay, Mr. Kustner. Sorry.
Thank you, Mr. Chair. Secondly, with reference to the submissions you heard from Mr. Cherniak relating to section 2.1 of the Planning Act. To be clear, the city is not asking this tribunal to have any regard to the decision made by council on May 14th. The evidence respecting that decision was tendered to make it clear as a factual matter that on that date, council rescinded the direction and resolution from the previous council session on May 13th, and to quote the wording of the resolution, that council direct appropriate staff and legal counsel to advise LPAT that it supports the proposed modifications to the secondary plan and proposed amendments to the opening zoning bylaw. We have, I think, indicated time and again that because that was a closed session meeting, no reliance is placed on any materials that were before council at that meeting for the purposes of section 2.1, nor for that matter does the city place any substantial weight of any kind on the fact that council made a decision on that date. The most relevant decision that council made for the purposes of 2.1 was the original decision to adopt the plan, but of course council no longer supports the as adopted plan. So obviously in my submission that should be of limited weight as well. The last submission I wanted to make before turning it over to Mr. Kahar relates to the submission made by Mr. Cherniak that the city has a credibility problem, as he characterized it. He referred to what he calls a major error in the double counting for the deduction for common areas, and then asked somewhat rhetorically, what other mistakes were made? Well, with great respect, particularly to city staff, that does a disservice to them. That amounts to an interorum argument. Yeah, it suggests, it's almost like a where there's smoke, there's fire type of submission. And in my submission, and with in fairness to city staff, the principle, he who alleges must prove, still applies in this tribunal. And if my friend is of the view that there were other mistakes, then it is incumbent upon him to demonstrate what those mistakes were. He can't simply suggest to you that because one mistake was made, there must have been a litany of other mistakes. You don't know what they are, but you should just assume that they may have been the case, and it creates a credibility problem. So those are my submissions, and I'm now going to turn it over to Mr. Kahar.
So, Mr. Chair, I'd like to begin by making an overall comment based on the submissions from Mr. Cherniak, and that is that I say they amount to an attempt to overcome the absence of professional planning and urban design evidence to support his client's objections. And what he's doing is, because he doesn't have that, he's providing his own opinions as to the effect of official plan policies, growth plan policies. He is, through his submissions, giving the evidence. Now, I want to go to what I think is the crux of Mr. Cherniak's argument, and that is the question of unit size. And I say there's no smoke there. There's no error there. The evidence was clear. Mr. Lee was cross-examined on this, and there was no double counting. First, I'd say, as it relates to the city, or Mr. Cherniak's witness, Mr. Patrick Lee, he pointed to the region and said, we took the region's number. I took the resident, Mr. Lee, to that very regional document. And what was counted? Amenity space within the 110 square meters. But now let's actually go to the forecasted document. And I want to bring that up just to highlight the point that there is no error, notwithstanding what Mr. Cherniak submits. And I think it's important to put this to bed. So you look at the total unit number calculation. It starts off with figuring out what is total non-res GFA. All of the analysis in the first three columns is trying to figure out the non-res GFA portion, nothing else. And then what do they do in the fourth row? They take that non-res GFA and they minus it from the total GFA. And what do you get out of as a result from that? The res GFA. And then what happens? They calculate by multiplying res GFA. So now they're adding back in the 15% that is the amenity space associated with the res GFA. The number's going up. Then what do? They go to calculate the portion of the res GFA that is townhouse units. And that's what's being calculated in the next row. And the row after that, they make an assumption of how many units would result based on a 200 square meter townhouse. And then they do a subtraction. And what is being subtracted? It is the GFA portion of the townhouse units from the total res. It is not the amenity space associated with the res. In fact, it's quite clear here. It says not including the 15% common area allotment. The portion that was even the amenity space associated with the townhouses isn't removed. Mr. Chair, this number is as high as it is because the amenity space is included within, and that being the crux of Mr. Cherniak's argument, a lot of the submissions he's made that flow out of that have no bearing. My friend took you to HDR's report and says, in part relying on his unit size analysis, they only analyzed 3.0 because he equates the residents and jobs of 14,000 to be 3.0 FSI. That's just plainly wrong, Mr. Chair. First and foremost, his only expert witness, Mr. C. Gobin, on cross-examination, confirmed that his opinion was 10,400 residents and jobs was equated to 3.0 FSI, not 4.0 FSI, 3.0 FSI. And then we have to remember what HDR did in producing its report. It's a peer review report. Step one in their report is they looked at the BA report, which analyzed 3.0. It didn't look at residents and jobs, it looked at 3.0, and confirmed they generally supported the findings there. Then they analyzed something more. And that something more was the jump from 3.0 to 4.0. Mr. Cherniak would have you believe that in fact, all they did was conclude that the BA report was generally okay, and then conclude that the very same analysis for 3.0 was generally okay, but now we're gonna ask for a number of additional criteria. That just doesn't make sense. Now, my friend made a number of comments regarding the holding regime. And he points out to various revised thresholds. But I say he misses the whole point on all of this. The H bylaw is 2 camps. He's talking about camp number 2. He's not even mentioning camp number 1. And what is camp number 1? The H bylaw comes into effect on all of the lands should the bylaw be brought into effect. It's there. Someone, no matter what, on day 2, well below 10,400, they've got to apply to lift the H. They don't get a free pass under 10,400. They have to apply to lift the H. When they go to apply to lift the H, they have to do a transportation demand study. That study has to analyze whether the proposed development can be supported by the infrastructure, the transportation infrastructure. Completely separate analysis. Then you go into the second camp, and that's where Mr. Cherniak has all of his comments and concerns. But we have to remember that's camp 2, that's an addition. The analysis in camp 1 is already happening. And a proponent needs to clear that analysis first. Now, Mr. Cherniak raised concerns about the change in the camp 2 analysis to the test being associated with building permits. And in our submission, that's not an issue at all. Building permits is when development will be realized on the ground, when development will result in people and will result in population that will trigger thresholds. And there could be big lag times between when a building permit is issued and when an H is lifted, and correspondingly when a site plan application may be filed in between. But that's not a problem, because when the next application comes and they go to lift the H, in addition to all those thresholds, what has to be analyzed? Back to camp number one. I need to make sure my transportation demand study can come to a conclusion that there's sufficient infrastructure to support my development. I need to analyze what impacts are being had on that infrastructure, so the monitoring will implicitly happen. Mr. Cherniak described Mr. Patrick Lee's evidence regarding heights and height limits as well. Look, I don't think it's ever been supported, or it's very challenging to support in front of the tribunal. And so I'm simply not going to follow that path no more. And I say that's just simply an oversimplification of Mr. Patrick Lee's evidence. Mr. Lee's opinion was that we need to take a more science-based analysis and rationalized-based analysis to height limits. It doesn't make sense to simply put a numerical number in. Instead, it has to be rationalized. And the city has put forth a plan that rationalizes that, utilizing a 45-degree angular plane, which you heard considerable evidence from Mr. Theodore. Mr. Cherniak submits that a 40-story limit should be imposed, but provided no evidence on that. There's no evidence supporting a 40-story limit being imposed in this KDA. Mr. Cherniak took you to the growth plan policies, and in particular to 5.2.4, and says, you don't need to worry about the 2041 time horizon. You don't need to worry about the targets that are in the growth plan today. Well, first, that's Mr. Cherniak giving evidence on this point. He never really put any of these policies to any of the planning witnesses that have appeared before the tribunal, and he very well could have if that was part of his submission in closing arguments. But second, I would simply point that 5.2.4, that relates to forecasts. What we're talking about are targets. Those are the targets that are in policy 2.2.4.3, the target for an MTSA, for example. And the policy that deals with targets is 5.2.5. And there's nothing in there that says you'll look at the old targets. You look at the targets that are in the growth plan 2019. And I realize I'm making submissions here on this, but the point is there isn't the evidence in front of you to suggest otherwise. Okay, Mr. Chair, I'm just going to hand it back to Mr. Kustner.
Sorry, one last point that I meant to address. Can you hear me now? Yes. Thank you. One last point I meant to address, Mr. Chair, and it has to do with the submissions made by Mr. Cherniak in reliance on the Niagara River Coalition case. That's the Court of Appeal decision, which is often taken as standing for the proposition that the interpretation of an official plan is a matter of law and not a matter for opinion by planning experts. I think it's important to understand that in the Niagara case, the specific facts were that the drafter of the official plan gave evidence that effectively said, I drafted that OP and this is what I meant when I drafted it. And it's in that context that the Court of Appeal issued its caution that this is really an issue of law, not a matter for opinion by planners. I think it's clear that since that decision was issued, both the OMB and LPAT and the courts have sort of backtracked, if I can put it that way. They have consistently reinforced the appropriateness of hearing opinion evidence from planners to guide their interpretation of official plan policies more generally. And unfortunately, because we only just got this case when Mr. Cherniak provided his submissions, I don't have copies of these two decisions, but there's two decisions in particular that I would refer to you in reply. One is a recent decision of the tribunal in the case of Green and City of London. It's PL190445, issued March 26, 2020. And I'll quote from that decision where the tribunal says, this is starting at paragraph 7 of that decision. In the off-cited case of Bell Himmel Investments in City of Mississauga, Justice Saunders finds at paragraph 22, quote, official plans are not statutes and should not be construed as such. It is the function of the board in the course of considering whether to approve a bylaw to make sure that it conforms with the official plan. In doing so, the board should give to the official plan a broad, liberal interpretation with a view to furthering its policy objectives. The tribunal in that case goes on to say, in the similarly leading case of Niagara River Coalition, Chief Justice Winkler confirms the proper interpretation of an official plan as a question of law, and then he then quotes the passage that Mr. Cherniak relies upon. But the tribunal then goes on in the Green case to say in paragraph 11, the parties do not dispute that the tribunal may consider the opinions of planners in exercising its duty, referring to Brian and Jane Legree versus Grey Highlands, where member Tusaw observes at paragraph 58, quote, the tribunal in the former OMB's jurisprudence is established solidly around the practice of considering the land use planning opinions of duly qualified professional planners. Such practice does not derogate from the tribunal rightly asserting its jurisdiction in the determination of planning questions before it as matters of law. So clearly the tribunal is, and that's a 2018 decision, well after the Niagara River Coalition case. So clearly on the one hand, the tribunal does acknowledge that ultimately the determination of planning questions before it are matters of law, but at the same time, it remains appropriate to exercise its traditional role of hearing from duly qualified professional planners to assist in that interpretive function. And the other case I would refer you to is a court decision, Balmoral Developments and City of Orillia. It's 2012 OJ number 5012. And there's reference in that case to the Niagara River Coalition case starting at paragraph 112, but in the subsequent paragraphs 113 on down to 116, the court goes on to say, notwithstanding the Niagara River Coalition case, that the law as it currently stands may or may not allow for the admission of expert evidence regarding the interpretation of official plans and bylaws, depending upon whether certain criteria are satisfied. And in this case, of course, you've heard a great deal of evidence from all the planners who testified as to the interpretation of official plan policies. In my submission, if someone was taking issue with the appropriateness of those opinions, the time to do that was before the evidence was tendered, not after the fact. So in my submission, it was perfectly legitimate for you to hear opinion evidence from Ms. Anderson as to her understanding and interpretation of Part 1 OP policies dealing with height and how height is to be regulated, and to give that evidence appropriate weight in the course of your interpretation of those policies. But when doing so, I would submit that it's important to bear in mind that her opinion in that regard is uncontroverted by any other professional planning opinion evidence. And if you're giving the official plan a broad liberal interpretation as you're mandated to do under the Bell Himmel case, in my submission, it is perfectly open to you to accept her opinion that the Part 1 OP policies requiring maximum heights do enable those heights to be regulated by reference to criteria such as angular plane requirements. Those do, of course, ultimately lead to a maximum height when you apply the policies. It just happens not to be a specific numerical maximum in terms of stories. There's always different ways to skin the proverbial animal in my submission. Those are my submissions. Thank you.
Mr. Chair, this is Mr. Cherniak.
Yes.
There was one thing that Mr. Kahar said about the calculation that nobody has said before. I have 1 minute just to give you an alternative interpretation on, because I think it's only fair. You'll make your decision, but you should know what it's going to this section that Mr. Kahar just read to you. That's all. So this says,
Mr. Chair, he can't do
Yep.
closing
No.
after
well,
my closing.
he
That's
brought
not how
up
this
something
works.
new.
Hang on.
This is saying that
This
the
is not how this
15%
works.
common area allotment is not part of the total residential GFA. That is what
It's
this
up
means.
to us
That's my
now,
point.
Mr. Cherniak, to decide based upon the submissions of both of you. And that's what we'll do, as you submitted it in original argument.
We'll read it carefully, we promise.
Thank you.
Thank you. That's it. Is that it? Okay. Thank you very much. And the only submissions you have to make are with respect to the timing, I mean, the March, April timeframe for all of you. And once we get that, we'll take a look at it. Anything else? Hang on. Thank you. Thank you all.
And
Thank you.
clocks get back with it.
My colleague and I, my colleague and I have agreed. That's it.
Thank you, sir.
And
Thank you.
Andrew, thank you very much for your contributions.